I'd like to call the Town of North Topsail Beach Zoning Board of Adjustment special meeting Wednesday, March 27th, 2024 at 6:04 p.m. First thing on the agenda is the oath of office, and Susan was unable to, she was approved absentee today, so we'll cross that off. And now the adoption of the agenda with the oath of office taken off. Can I get a?
I make a motion to accept the adopted agenda as amended, removing item 2.
I second.
All in favor?
Aye.
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 Next on the agenda, the approval of the minutes from February 29th, 2024, special meeting.
I make a motion to accept the minutes from the February 29th, 2024 meeting.
And I second.
All in favor?
Aye.
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 New business, and next on the agenda, case A24-000001, appeal by Matthew Davis, Coastland Construction, LLC.
Madam Chair, this is a appeal hearing. However, before we start the preliminary instructions, it's been brought to my attention that there may be one or more board members that feel the need to recuse themselves for this hearing. Is that correct, Mr. Drazio?
That's correct, I received a letter.
Okay. I take it, Mr. Drazio, based on whatever circumstances you feel that you cannot be fair and impartial tonight?
Well, and like I said, it's a conflict of interest. I was on the ARC board at the Village of Stone Sound where the violation was.
Okay. All right, is there a motion to recuse Mr. Drazio from participating in this hearing?
I make a motion to recuse.
Can I get a second?
I second.
All in favor?
Aye.
Aye.
Thank you.
Okay.
And you'll be available if we
Yes.
continue,
Yep.
need to continue for something else. Thank you.
Thank you, sir.
Madam Chair and board members, that leaves us, by my count, with only 4 sitting members. Unlike a variance, this is an appeal which requires a majority as opposed to a 4/5 vote. However, I would like to hear from the applicant's attorney, Mr. Stephen Coggins, as to whether the appellant wishes to proceed with only 4 members tonight.
Thank you, Mr. Eads. And for the record, I am Steve Coggins of the firm of Brauntree Losi in Wilmington, North Carolina. And I represent specifically Phil and Kristen Buckley, who are the property owners, and to whom the citation for the penalty was issued. We cannot stipulate to only 4. However, we do bring it to this board's attention that a blessing that has come to us by the legislature recently is to allow for mediation at this stage of quasi-judicial proceedings. And we do believe this is a case that's very appropriate for mediation. And we would suggest that all the parties pursue that. There are no rules set forth in the statute about how one does mediation other than the fact that you have a mediator. But basically what it requires is for both sides to agree to mediation, that is, Buckley's and the town, and each to designate someone that has authority to represent the entity in the mediation, and we would mutually agree to a mediator. And so we do commend that to you for your consideration. And so while we don't stipulate to only 4 for the purposes of the merits, we do believe it's appropriate and would stipulate to the 4 making a decision about whether or not to go into this voluntary mediation process.
Thank you, Mr. Coggins, or Attorney Coggins, I'm sorry.
Mr. Coggins, sorry, should have caught you before you sat down. As you just indicated, this is a relatively new vehicle made available to towns and appellants. If the Board of Adjustment's inclined to go forward with mediation, since they are the body that's appropriately constituted to hear an appeal from a staff decision, as opposed to other components of the town. If they are inclined to move forward with mediation and designate 2, I don't think we can do 3 because that would be a quorum and would require basically an open meeting. Do you have any objections to those 2 being at the mediation as decision makers? And if for whatever reason the mediation's not fruitful, then coming back and hearing the
No
appeal?
objections.
Okay. Thank you.
Attorney Edens, may I ask a quick question?
Yes, ma'am.
The people that would, the 2 persons that would be appointed as the mediation, they would be from the board or they would be staff?
Again, there's really no as Mr. Coggins pointed out, there's really no guidance from the General Assembly on that, but to my way of thinking, since the appropriate party to hear and rule on appeal is the Board of Adjustment, we would want the voice of the Board of Adjustment at the mediation. You could bring staff members there for purposes of facilitating the mediation. I'm sure they'll be presenting some sort of argument to the mediator. Likewise, and by statute, the staff member whose decision's being appealed from is required to be at the appeal hearing, tonight's hearing, so I would suggest that that person equally should be at any mediation.
And you would represent the town in that mediation?
Most likely, yes, ma'am. So, as a first matter of business, sounds like Mr. Coggins is not willing to go, understandably, it's his prerogative since we don't have a fully constituted board tonight. So, if we need to continue this until we can get 5 members present, we need to do that in conjunction with discussing in the meantime, is the board inclined to proceed to mediation? And just for the minutes, that the mediation component comes from North Carolina General Statute 160D-405, subsection G.
And all parties should have a copy of that in their packet.
And likewise, our Code of Ordinances, section 2.03.05, again, G, mirrors the general statute provision, so that vehicle is in both the North Carolina general statutes as well as our Code of Ordinances.
Mr. Eads, as a point of order, I would also like to suggest this is not far from it, this is not a tactic of a delay. We're very much in a hurry. My clients have significant debt service and loss of income they're experiencing because of this deck not being built. We very much would suggest that the formal thing that would happen is a continuance of this hearing until, say, the next regularly scheduled one, but with accomplishing the mediation in the interim.
In the interim, yes, sir.
In the interim, okay.
Yeah.
That's what I meant to forecast, if that's not what I forecasted. First order of business would be to continue it to the next regularly scheduled meeting, and then if we're able to come to some sort of a agreement as to mediating, we would do that in the interim.
So the board, are there any questions or comments before we continue? No. Does somebody want to make a motion to have a continuance towards mediation?
I make a motion to have a continuance till, and have mediation in between. Continue it till
Well,
April.
can we take them one at a time, just so it's
Sure.
cleaner? The first
Okay.
motion would be a motion to continue to the next
I make a
hearing.
motion to continue to the next regular scheduled meeting in April.
I'll second that.
All in favor, or do we have to call the roll? All in favor?
Aye.
Aye. Okay.
All right, and is the Board of Adjustment inclined to pursue mediation in the interim?
I make a motion to pursue mediation in the interim.
I second the motion.
All in favor?
Aye.
Aye.
All right, does the board want to designate no more than 2 members of the Board of Adjustment to attend the mediation?
Well, this is where I'm not going to be available at the end of this month, so I don't know if I should be a representative
It
if I
would be
could
in
not
April.
present
You're not going to be available in April?
at the
Okay.
April. So I don't think I would be appropriate to sit on the mediation, just because if I had to report back, I wouldn't be available to report back.
I will volunteer. Anybody else want to volunteer?
You can. My best April's busy.
Okay.
Okay.
Yeah.
So,
So a motion to
Motion.
appoint the 2 of you?
And you could always, if I may, you could always appoint Susan, since
Oh,
these
Susan.
two are tied up, you
Sorry.
could appoint Susan Meyer in the event as an
Alternate.
alternate to one of those two not being able to attend for whatever reason.
Well, I don't think it matters to Mr. Coggins who's there, right?
well, just as long as somebody's there.
So at this point, without the
I'm
benefit.
not saying I shouldn't matter, but.
Well, but what I'm saying is, your objective would be to have a fruitful mediation.
Correct.
Right.
Ours
Since Ms. Meyer's not here, I would recommend we just,
Okay.
good suggestion, but since she's not here, don't know her availability trouble.
She doesn't get to vote in the matter.
What's that?
She doesn't get to vote in the matter.
I recommend if we're going to appoint someone, it should be from this board as constituted this
And
evening.
if something would come up that there would be an emergency or something, then we could appoint someone else if that's agreeable.
Right. Again, internally, I don't want to speak for Mr.
Right.
Coggins. I don't know that it matters to him as long as there's someone there
Okay, right.
with the authority to resolve this, so.
Okay.
So if you want to make a motion to appoint the 2 of you.
Make the motion to appoint us.
I make a motion that we appoint Lisa and Hannah to the
Mediation.
mediation.
And I'll second that.
All in favor?
Aye.
And just so we're clear, the scope of an appeal, as far as the Board of Adjustment's role is to ascertain whether the staff member whose decision's being appealed from properly interpreted and applied the ordinance. And then, once you make that decision, your options would be to affirm, reverse, or modify that order. And the citations that we're here for tonight are, or it's citation 23-00117 that pertains to town ordinance 10.02.02 and 10.07.02. I just want to define the scope of what we're talking about here. Mr. Coggins, do you?
Brian, I missed you. I've got a town citation by that case number you gave me, and it cites 10.07.02 sub A.
Okay, if you'll look at the bottom right-hand corner of that citation, as well as your
Okay. client's
appeal, it cites to both of those statutes.
Okay,
Or both of-
10.02.02?
Yes, sir.
Yes, all right. Mhm.
And the appeal that was submitted also states that that's what they're appealing from, Mr. Coggins?
Yes.
Okay. So we can agree at least that there are 2, and those are the 2 violations that are being appealed. It's in one
And
citation.
and the subject of the mediation, yes.
Okay. All right. Thank you.
I would suggest that I would advise my clients to stipulate to the rules regarding court-ordered mandatory mediations in Superior Court, perhaps with the exception that the mediator need not necessarily be a certified mediator.
Sure. I mean, the statute's pretty flexible. In fact, it contemplates something, alternative dispute resolution other than mediation, so I don't think anyone wants it to be an exercise in futility, so we can agree to that.
Who will make those arrangements? Who will make the arrangements for the mediation?
I'll work with the town attorney to do that.
Right, and town side and the appellant side need to agree on who's going to serve as the mediator, which I don't think that'll be a problem
I think we can stipulate that, even broaden the pool. It
Sure.
doesn't necessarily have to be somebody who's certified.
Right, right.
All right, then. The case is continued. Case A24-000001 is continued till our next scheduled meeting with mediation to be, proceed in between there. Any other discussion from,
With the consent of the
oh,
appellant, correct?
Yes.
anything else that needs to be discussed before we
Just a
adjourn?
point of order, is that, when is the date of the next regularly scheduled meetings?
Town attorney's availability.
It's generally the last week of the month.
On a Wednesday?
Not necessarily, but it's not set yet, and we'll work to the best we can with you and your clients and your witnesses' availability to schedule that.
Would this be an appropriate time to ask about submitting a new permit application to the town as well as to the county folks regarding a new location for the stairways?
It's probably outside the scope of what we're here for tonight. I know it tangentially may relate because it's the same property, but I'm sure Ms. Hill will talk to you at the conclusion of this meeting. I just don't want to muddy the waters.
Understand. At the same time, I want the bill being to make all facts available to the town for purposes of what they think is appropriate for assessment of the penalty. That's all.
Could you say that again, Mr. Coggin?
We want to make sure all facts are fully developed so that the town has all the information it needs as to what's appropriate for the assessment of the
Right.
penalty.
And presumably by the time we get to mediation, that you'll have whatever discussions you need to have with staff. I'm just saying, we're kind of in this gray area here where we haven't opened the evidentiary hearing. And ultimately, if the mediation's not fruitful, these folks are going to have to base their vote on the actual evidence that is presented. And they hear what you're saying. I just want to be careful that we don't cross that line.
That's why I asked.
Yes, sir.
Can I get a motion to adjourn?
I make a motion to adjourn the special meeting.
I second.
All in favor?
Aye.
Aye.